Amendments. Senator Cruz.
Mr. Chairman, I've got three different amendments that I want to call up. As the chair knows, I am a strong supporter of criminal justice reform, and in the 9 years I've served on this committee, we have had these debates back and forth. There have been times when the chairman and I have been side by side with criminal justice reform and proposing it together, and there have been times when we have been opposing each other. And for me, the distinction has really been on two criteria. Number one, the criterion that Senator Cornyn just raised, and I commend Senator Cornyn for the amendment he introduced. I think it was a good amendment, which is the retroactive application of sentencing reform. And the problem with that, and this is reminiscent of some of the comments Senator Whitehouse raised with the previous bill, is as a practical matter when prosecutors are bringing cases against a criminal defendant and there's a whole array of conduct that can potentially be charged. When a plea agreement is reached, it is not uncommon for a prosecutor to reach a plea agreement on some of the lower charges and not prosecute the more serious charges if the plea agreement gets a sufficiently serious prison sentence that the prosecutor feels he or she is justifying their obligation to the public. The danger of retroactive sentencing reform is that you can have what on its face appears to be a nonviolent conviction that was in fact a violent episode, but the prosecutor accepted a plea deal because there was a sufficient prison term to be justified given the conduct. And going back retroactively risks undoing the bargain that was reached. Prospectively is very different. If a prosecutor knows what the rules are that will attach to any given sentence, then the prosecutor can make a judgment in terms of what pleas to accept and what pleas not to accept. So that's one area I've had long concern. A second area of concern, and I would say an even greater area of concern, is violent crime. For me, there is a qualitative difference, a line in the sand between violent crime and nonviolent crime. The reason I have been supportive of multiple efforts at criminal justice reform is that I do agree with nonviolent offenses, particularly nonviolent drug possession offenses, that our criminal law had sentenced too many defendants to overly long sentences not justified by the conduct. I think it's fundamentally different when someone engages in a crime of violence. Many of us on this committee have worked in law enforcement. I have spoken with parents whose children were raped and murdered by vicious criminals, and I have no desire to speak with any parent in that circumstance again and to be remotely responsible for releasing the rapist or murderer that committed that horrific crime. I view crimes of violence as qualitatively different. I would point out on the First Step Act, as this committee has considered various versions, initially when I got here, I co-sponsored with the chairman versions of criminal justice reform. Then the legislation got broader to encompass violent crimes. I stopped supporting it. We had markups in this committee where I introduced amendments to carve out violent crime, and the committee rejected my amendments. And I remember sitting in this room saying, there are the votes to reject these amendments on the committee, but if the amendments are not adopted, this will never pass the full Senate. It turned out that prediction was exactly right, that the amendments were rejected in committee, and then they didn't pass the full Senate. When the First Step Act was adopted, as the chairman will recall well, I was one of the last senators to get on board with the legislation, and I had a very explicit price, a series of amendments carving out violent crime so we would not be releasing violent criminals early. And the chairman ultimately agreed to those amendments. I supported the bill, and just days later the Senate took it up, passed it, and a number of us were at the signing ceremony in the Oval Office shortly thereafter. So I think criminal justice reform is important, but I don't think we should be in the business of releasing violent criminals early. In the spirit of those sentiments, I want to call up initially Amendment ALB 21901. This amendment strikes the section of the bill that allows judges to waive mandatory minimum sentences for repeat offenders. The law already allows judges to sentence drug offenders without regard to the statutory mandatory minimum if the offender meets certain objective criteria, including that they have not more than 4 criminal history points. Criminal history points that are a fair and objective and consistent measure of the severity of an offender's criminal history based on their prior convictions. Section 102 of the First Step Implementation Act would allow judges to disregard this objective measure of criminal history in order to impose a sentence below the statutory mandatory minimum based on their personal view of the seriousness of the offender's prior criminal activity. I think this is, in effect, an end run around the mandatory minimums, and it is likely to lead to the very sentencing disparities that specific and objective criteria are designed to oppose. And so I urge a yes vote on the amendment and ask for a roll call vote.
Let me make sure it's clear which amendment you're offering. This is ALB 21901 relating to the safety valve?
Yes.
Okay. I'd like to respond then to what the senator from Texas has said. Let me start off from the beginning for those who are new to this conversation. We decided that the war on drugs needed to be re-examined because it didn't work. It didn't work. It didn't reduce the use of drugs. It didn't reduce the supply of drugs on the street. It filled the prisons, literally, to record-breaking numbers, primarily with minority defendants. And by the tens of thousands, they languished, many of them not just for years, but for decades. And we decided that putting mandatory minimum sentencing into this category of nonviolent drug offenders was fundamentally wrong and unjust, and we stepped out to try to change it. That's what it was all about. That cause grew in momentum to the point where it included not only the usual suspects on the liberal side, but even on the conservative side, where they said this just isn't fair. We're sentencing people way beyond what should be the case, and it isn't really fair to them, nor is it making America a safer place. That debate encompassed so many different people. I found myself in company of the Koch brothers, for goodness sakes, who were agreeing with us on this, and ultimately signed into law by President Donald Trump. So here we had Democrats and Republicans finally saying mandatory minimum sentencing should not be the case when it comes to certain categories of drug offenses. But we said, if you are a person who has been sentenced, this isn't automatic. You have to plead your case. You, the criminal defendant, have to come forward and make your case of why your sentencing should be reduced. Have you ever been involved in any of these cases when someone decides that they're going to try to get their sentence reduced under the First Step Act? This is not a matter of filing a piece of paper. I can recall cases in Illinois where they went to the prosecutors and asked them if they thought this was fair to reduce the sentence of an individual. They went to the judge, the sentencing judge. They went to the victims. They really did due diligence to make sure that they'd asked every question and understood where justice ended up. It was not an easy task for people to get that result. And so we have done with this bill, underlying bill, is to make this retroactive so that a criminal defendant can get into this process and try to get their sentence reduced. Senator Cruz has a different point of view. He believes, I think, that we ought to have hard guidelines, as we did with mandatory minimum sentencing, when it comes to situations. And this is involved. His amendment strikes the safety valve provision of the bill. The federal safety valve allows a judge to sentence below a mandatory minimum for a low-level nonviolent drug offense if the defendant meets certain requirements, including cooperating with the government and having a specifically defined limited criminal history. This First Step Implementation Act would allow a judge to apply the safety valve if the defendant meets all other safety valve requirements and the court finds the criminal history substantially overrepresents the seriousness of the case. The defendant has to go through the whole process of making his case about resentencing. The judge has to be convinced of this. It's an individualized case. I think that is what we had in mind with the original First Step Act. Senator Cruz disagrees. I hope we will defeat his amendment. Is there any further conversation on the Cruz amendment?
I want to speak on it.
Senator Grassley.
The First Step Implementation Act provisions on the safety valve I think simply give judges more discretion to determine if a defendant's criminal history warrants a mandatory sentence. Safety valves are meant to increase opportunities for individual assessment, not release dangerous individuals into society. So, consistent with existing law, a judge cannot apply the safety valve unless the defendant has fully cooperated with law enforcement and has not used or threatened to use violence or firearm caused death or serious bodily injury, and was an organizer, leader, manager, or supervisor of others in connection with offense. So I think that this goes well beyond what we had in a compromise on the First Step Act, and I'm going to vote no. There's several of my Republican amendments that I was going to vote for. I thought Senator Cornyn, I agree with him that violence is important to avoid, but his amendment was too broad, and I voted against it. I prefer Cornyn's amendment on just 924C defendants. There was another Cruz amendment I was going to vote for, but I can't vote for this one.
Senator Lee.
Just want to clarify once again, this amendment deals not with whether or not we're going to give relief to those convicted of serious violent felonies. In fact, so the sole purpose of this amendment is to strike Section 102. Section 102 specifically excludes from this safety valve serious drug felonies and serious violent felonies. So this isn't about whether or not you want to provide relief to those categories of offenders. That's off the table. All Section 102 is doing, and Section 102 is the one provision stricken by this amendment, is just expanding the universe of cases in which it can be applied based on the defendant's criminal history. In other words, there are pretty rigid restrictions currently on how many criminal history points an offender may have if the judge is to invoke the safety valve. And so that's all this does. We're just talking about a mild expansion of the criminal history eligibility of an offender. It doesn't have anything to do with serious violent felonies, which are excluded. So I oppose the amendment.
Mr. Chairman. I will say my friend Senator Lee is right that this amendment is not focused on the question of violent crime as my next two amendments are, and so I look forward to Senator Grassley voting for the next two that come up after this. But this is focused on repeat offenders, on career criminals that commit offenses over and over again. And I will point out, anytime in sentencing, federal sentencing law, state sentencing law has over the decades careened between two poles. On one pole is wide and sometimes unlimited discretion for judges to set a sentence. The downside of that is you end up with wildly unfair disparities depending on what kind of judge you get. You get a hanging judge, you get a terribly high sentence. You get a nice judge, you get a very limited sentence. And so the reason Congress came in and passed the entire guidelines is to say we should have some uniformity. It's not right that two defendants who committed the same crime should have such wildly different sentences when the underlying facts are quite similar. Now, the law then is careened the other way, which is very rigid mandatory minimums and strict requirements. That has the benefit of uniformity and predictability, but it also has the downside of sometimes having unfair instances because it is less able to respond to the extraordinary instance. And I think we got to have a balance between the two. It is why I have supported multiple times criminal justice reform relieving mandatory minimums, because I do think they can be unfair. I will point out enhancing the discretion of individual sentencing judges has some downside, and even more downside if the judges tend to skew one way or another. And we're sitting here 6 months into the new Biden administration. One thing that is quite striking is that every single Court of Appeals nominee President Biden has put forward, with the exception of the Federal Circuit that we've considered, 100% of them have been federal public defenders in their career. As this committee knows, a lot of judges sometimes are prosecutors, sometimes are public defenders. It is striking that in a criminal justice case you've got two sides, and right now all of the Biden Court of Appeals judges are from one side, the federal public defender side. Now look, a good judge is supposed to follow the law regardless of the sides, but enhancing discretion, if you have a bunch of judges who naturally side with the criminal defendant, enhancing that discretion to ignore objective criminal history criteria, I think is ill-advised.
I might just add for the record, we noted at yesterday's hearing of 50 federal circuit judges, 2 have a history of being public defenders. So President Biden has made it clear he wants to bring some balance to the circuit courts, and I don't think he has concealed that in any way. That's the way he feels, and I happen to agree with him. Pending before us is the Cruz amendment, and I want to make sure I have the right number. ALB 21901. Any further discussion? Want a roll call, Senator? Clerk will call the roll.
Mr. Leahy?
No.
Mrs. Feinstein? No. Mr. Whitehouse?
No.
Ms. Klobuchar? No. Mr. Coons?
No.
Mr. Blumenthal? No. Ms. Hirono? No. Mr. Booker?
No.
Mr. Padilla? No. Mr. Ossoff? No. Mr. Grassley?
No.
Mr. Graham?
Aye. By
Mr.
proxy.
Mr. Cornyn?
Aye.
Mr. Lee?
No.
Mr. Cruz? Mr. Stas?
Aye by proxy.
Mr. Hawley? Mr. Cotton?
Aye by proxy.
Mr. Kennedy?
Aye by proxy.
Mr. Tillis?
Pass.
Miss-
Aye.
Tell us pass it.
Mrs. Blackburn?
Aye by proxy.
Chair Durbin?
No. So I thought I was thumb up, and I thought he was for Blackburn.
Chair Durbin, the votes are 7 yeas, 14 nays, and 1 pass.
The amendment is not